Can you hear me?
Hi, everybody. My name is Rochelle. Nice to meet everyone.
So you're the one we're gonna be talking to again.
Yes,
Okay.
I will be the new the new board admin for you guys. So
All right. So the email best to use is just the general box. Is that what you have?
yes,
The-
the board commission's email is the best email to use.
So you don't have a direct email.
I do have a direct email, so I can share that as well. It's
But
going to
we do,
be,
yeah.
but we do prefer everything to go through that board email, so then it all stays in that central location.
All right. Well, welcome and we appreciate all what you're doing for us.
Of course.
The first thing is to approve the minutes. May 7th minutes. Need a motion?
Motion to accept.
Second?
Second.
Okay, any discussion? Ted, any discussion, Ted? I can't hear you, Ted. You're muted.
How's that? Am I on now?
That's great. That's great.
No, I didn't find anything. Minutes look good.
Wow. Okay. So all in favor?
Aye.
Aye.
Opposed? Opposed? Accepted. Okay. Legislative update. Okay. Julianne, are you here?
Hi, good morning. Julian is not here this morning. She was called into a meeting with the governor's office. So Ryan Burns is here along with myself to answer any questions or discuss anything related to legislative action. So I'm Leslie O'Brien. I'm the legislative director. And for those of you who I haven't met before. And I know we already talked a lot about House Bill 6769, which passed and will be taking effect, over the next year. And now we also have proposed regs to, amend the current regs as a result of House Bill 6769. And Julian, I know, sent around a draft for you to start to take a look at. We have some time, so certainly if you haven't had a chance to fully review, there is still time, but we're here to answer questions about that, and Ryan's here to answer questions about those proposed regs and anything else you have questions about regarding the legislative session.
Okay, as I was reviewing this, we actually approved the changes or made it at the draft, approved on our meeting on February 1st, 23. I guess the question is, I don't see anything changed. Anybody had a chance to download Public Act 2384 and went over it?
Yeah, no, I'm sorry. Right, you did approve those.
Yes.
If you have more questions about the Public Act or House Bill 6769, same thing, that's fine. I think what more importantly, I think, is the draft regulations that have been sent to you last week by Julianne as a result of the Public Act. So updating the regulations as a result of the changes made in the Public Act.
Was there anything in the changes that that didn't approve in February?
In the changes to the regulations?
Yeah, that we did. Otherwise,
Mr. Chair, and there were some modifications to the Public Act that were made subsequent to the approval, but I think those have also been discussed at prior meetings.
okay.
Yeah, I think
for-
there's confusion. Sorry, Ryan, I'm sorry to cut you off, but the regulations, you should review the proposed regulations, proposed changes to the regulations, because while they in part codify changes made as a result of the Public Act, they, you know, the regulations are being updated too. So there may be other things in addition to what you agreed to in the Public Act. So you should definitely review the document Julianne sent around last week.
Okay. I guess my question is that I haven't compared it. I'm not sure if anybody did, compared to what we did approve, if there was at least any changes.
Are you
Which is-
saying changes between the Public Act and the regulations, or are you just saying the Public Act itself from February to when it,
That's
till
correct,
final passage?
right.
The Public Act itself from
Public-
February to final passage?
That's correct.
Okay, so there were a few changes that were made after February based on push, feedback from the legislature and what they were willing to pass. So there were some changes made by the legislature. Most notably, the leasing agent language was changed.
Could you give us that section, Leslie, please?
I can, hold on, let me just find it, sorry. Section 7,
Thank you.
When were these, when was this act mailed to us?
Act. No, I don't believe that the Public Act was emailed to you at all. The Public Act, once we worked with you all in the Connecticut Realtors Association, then it went to the legislature, and then it was really in their hands. And so this is
Now, I
what was done.
understand the process. What I want to know is when was the copy mailed to the members of the commission? Emailed
It was emailed the 27th
of,
of July. This whole new, from Julianne.
yeah, I'm not sure I got it. Thank you.
Commissioner Burnham, those were the regulations, not the Public Act.
Okay, well, I'm sorry, wrong phrase, but
Sorry.
I don't
She
believe I got,
linked to the Public Act in the email, though. So Julianne linked to the Public Act, which is the new approved Public Act, correct?
And that's what I
That's
found.
correct, that's
In
correct.
that email.
That's correct.
Okay.
Yep.
All right, so I read
Thank you, Amy.
Julianne's 22-page document. And so who are the people or groups that have made the suggested changes to the regulations? Like, where does that come from?
So
Is that from
I'm
our
sorry,
discussions in
Leslie,
the past? Is
I
it
can
from
speak to that
people?
unless you'd rather dive in.
I mean, this is a draft, and we're now sending, it was sent to you and also to the, to CTR for feedback. So the legal division, Ryan and the team, and Ryan, Julianne and the legal division team, based on the Public Act, amended the regulations, and they put this draft together to send to you for feedback and to the Realtors Association.
Okay,
Yeah, so this is predominantly coming to accommodate the Public Act and to make some of the regs more readable and more organized. But this was not the result of requests from outside participants in the industry at this point.
and from my understanding, the underlined words are what has changed and the bracketed words are what was there before.
Yes, those
the
are being
bracketed words
deleted.
are being deleted. The underlined words are being added. In addition, there are some new sections that are not underlined, but at the beginning, it'll say this is a new section.
Okay,
I can walk through a couple of highlights if you're interested in what beyond just organization, if that would be helpful for the discussion.
I'd be interested what the comments was from CTR. What were any comments?
Not yet, not yet. They were sent they were sent to them on the same day as you, and they are reviewing still. So we haven't received any feedback yet.
Yeah, if we could get a high level overview of what you thought were the key changes, that would be helpful, please.
Absolutely. So, one issue that I know has been of particular concern is the approval of mandatory courses. So within this
That's
proposal,
towards
we
the
put
end, right? Can you tell us what page or section you're referencing,
Yeah, there's
please?
no page number here. Okay,
so this
There's a-
it's on page 7 of 22. It's within section 20-328-11A sub B. It says continuing education course approval.
Could you say that one more time, Ryan, as I'm scrolling through? I'm trying to find
Yeah,
it.
absolutely. So it's on page
I don't.
7 of 22,
Mine isn't paged, so
and it's in section 20-328-11A. Course offerings and locations is the section title.
Okay, so we have a different document than you're looking at, because page 7 for me is a form.
Oh, okay. So
She combined, I don't.
It's just a suggestion. If you hit Control
Oh.
F and then type in course,
Okay,
you'll probably find it that way.
or mandated. Mandated will give you directly just that section.
okay, yeah, there it is. So it's page 17 of 22 for the 22-page document.
Okay.
It's at the very bottom.
Yep. Continuing education course approvals. We have, after receiving feedback from the commission, created some timeframes for submission and approval. So there won't be the confusion over people submitting applications to teach mandatory courses after the period has already started. And that will give the commission time to review those and either approve, deny, or request for modifications as a result of those conversations. It also empowers the commission specifically to dictate what needs to be included in mandatory course curricula.
Ryan, so are we gonna be approving the courses before, as you know, the department has been approving them?
Only the mandatory courses. So
Okay,
the mandatory course, as has been the practice currently, that has caused some concern. The mandatory courses are all going to be submitted to the commission for review and approval.
All right, so, and then it says, so shall be submitted to the commission not later than 4 months prior to the next continuing education period. So if that education committee is meeting, we typically, I think we have the course approved fairly close to the next mandatory training period, or the time frame, isn't it?
Is that a question to me? I'm not familiar with that schedule.
I don't know. Ben, do you remember? So when we have the education committee, we approve a mandatory course, and then it's typically reviewed and voted on by the commission whenever our next meeting is. But then I feel like it's fairly close to the deadline for starting that next 2-year cycle, right?
that's correct, and it's been a
Okay,
problem.
so any schools would have to get us their suggested approved course while we're coming up with that content. So that should be fine. Okay. I'm okay with that. The 4 months prior, that's fine.
At least 4 months.
Yeah.
Okay,
Any other concerns or questions about that section?
I don't, anybody else?
There have been some other changes, just to note that it looks like we may be taking out our ability to enforce provisions. Those, and there are notes in the document that you received that indicate that those are not, in fact, being removing powers, but they're redundant of statutory language. So those powers are statutory, not regulatory, and having redundant regulations can pose problems especially when there have been conflicts between the language. So if you see deletions, just note that often those deletions are not substantive, but rather just cleaning up technical changes. At the very bottom of the document that you received, there's a discussion of school denials. So if there's an application for a course or a school that we have concerns about, it'd be referred to the commission, and the commission could approve or deny a course or an organization or a school. We've added a section that provides a mechanism for appeal of those decisions. We don't think that's a particularly controversial provision, but it is something beyond the scope of what was in the statute. So wanted to flag it for the commission in case there was any questions or concerns.
Was my understanding we could always do that anyhow. It's the appeal now? Am I
Right, we're
correct?
giving an avenue for them to appear at a hearing and say that I shouldn't have been denied for this ability to teach. It's arguably required by due process, but we wanted to flag it for you just to understand that it's a new process that would be open to schools and instructors. A lot of this, again, is technical changes or to come into compliance. We did also consolidate a lot of definitions out of the document. Again, these definitions were redundant of what was in the statute, and we're trying to, again, ease readability. We did expand again. The leasing agent has now been incorporated into these provisions as been detailed in the Public Act. So they are now encompassed within the licensees that are discussed, even though they don't hold a credential. There's also some additional advertising requirements in section 20-328-5A, subsection G. It's how salespersons and associate brokers advertise. I don't think any of that is going to be particularly controversial, but it is kind of detailing additional requirements on advertising for people that are working under brokers. I think those are some of the big hits as far as the changes in the document that are substantive. Oh, there is another provision in 20-328-A prohibiting real estate courses from being conducted on the premises of a real estate brokerage office or a franchise or appraiser's office. Again, I don't think it's going to be controversial among this group, but I wanted to flag it as a substantive change.
I thought that was always the case.
It's more explicit now.
Okay, because it prompts recruiting essentially, which they're not supposed to be doing if it's at a brokerage office. Okay, I always thought it was a rule already.
I'm glad by the way, just going back the advertising, I'm glad it's a little more specific, especially on the font sizes. We've always had problems, whereas you can't find the brokerage or the broker in the advertising from the associates. So that's a good thing.
So big picture, largely these are either cleanup issues or issues to bring the regulations in compliance with the Public Act that was passed. There are a few substantive changes which we've discussed, and we're happy to answer any questions you might have, or if there are any other issues that you think were not properly addressed within this document.
What's our deadline on this?
Leslie, I'll kick that to you as far as schedule.
Leslie? Let's have a deadline to review this and make any changes. Or
Right,
guess-
but feedback from you all, because you take, please feel free to take this and digest it in case you have any other questions. And then also, CTR, and then once that's done and they are submitted to go through the pipeline, they have to go through, the governor's office approves, OPM approves, and then the AG, and also there's a 30-day public comment period. So all in all, regs like this, it's probably going to take, 6 to 9 months, if not, if there aren't any hitches.
I'd be kind of curious what CTR's view on this is going to be.
Yeah, well, we'll be happy to share that with you once we receive feedback.
That would be, appreciate that.
Okay, no problem.
All of us would.
Leslie, what's our deadline for getting back to you? Is there,
It would be great if you all could get back to us within the next, week or two. That would be, next week would be great if that's enough time. It's summertime and people are, vacationing and doing other things, but a week would be fabulous, 2 at the latest. If that's okay.
But we may want to have a discussion among us, review it now and discuss it among us.
Yeah,
So we can have different opinions.
sure.
Nice.
We totally understand. And so, if for some reason with vacation schedules and whatnot, you need more time, please feel free to let us know. We just, the longer this takes, the longer everything else will take. That's all. So we'd love to get this moving, but we understand. We want you to feel comfortable with this and provide feedback. So thank you.
And just to, I guess, state the obvious, if there is going to be a group discussion that involves a quorum, we'll want to schedule it as a special meeting.
Okay. All right.
Unless there are any other questions on the document, I'll step back at this point. I also do want to recognize the excellent work of Ben Paholke, who's on this call, who did all the real heavy lifting and putting this together for us. And I think he did a fantastic job. So thank you to him as well.
Thank you, Ben. Any other questions before we move on? Okay.
Thank you all.
Thank you. Okay, next is, so actually, I'm sorry, Jason, so if we need to have a special meeting, then we'll just contact Rachel.
Yep, absolutely. It's actually Rochelle.
Michelle, I'm sorry.
But yeah, Rochelle can definitely help you schedule that.
All
Absolutely.
right. Thank you. Okay, waiver request application review. Art? Yeah.
Yes,
You
good
may-
morning. I'm here
Yeah.
and my attorney is here.
So, tell us, are you looking for a waiver?
So actually, I think there's a little bit of miscommunication. I had been emailing Brian Cafarelli over at the Commission of the DCP, and it is not a waiver we're actually looking for, because if you read the plain language of the statute, Ms. Diana Hart actually qualifies under the current 2023 statute for broker license applicability to take her test. So one of the things that's really important to look at is the qualifying factors of Part B of the new statute, talking about after January 1st, or talking about after January 1st, 2022. And so the qualifying factor that it says is that the person has to be actively engaged for at least 1,500 hours And the qualification timeframe to finish those 1,500 hours is during the 3 years preceding the date of the application. So a person cannot say, I did 1,500 hours 10 years ago. It would not meet the qualification because the time frame they give you to have committed the whole 1,500 hours is within those previous years. But obviously, a person could do 1,500 hours before 3 years. It doesn't take 3 years to do so. So a person who has completed 1,500 hours, as long as it was done within the last 3 years, qualifies under this section, under this newly drafted statute. It's very similar to the language of the later qualification that says that the person has to have committed at least 4 real estate transactions during those 3 years as well. Obviously, a person can commit them within 3 years. It doesn't take 3 years to do 4 real estate transactions. But what the statute is clearly getting at is that 3 years is the time frame they want you to have done all this stuff so that it's fresh in your mind. You can even compare that to the old statute that specifically, and this is where it's really different, it says the person has been actively engaged for at least 2 years. So that old statute clearly says you need 2 years, and that is an end all be all. You have to be actively engaged for 2 years. But the new statute says you have been actively engaged for at least 1,500 hours. So the qualification of what that person needs for experience has been changed from 2 years to 1,500 hours. And when did the 1,500 hours have to have been done? Within the last 3 years. Miss Diana Hart finished her 1,500 hours in 2 years. And in fact, she completed 16 transactions in 19 months. So under the statute, she clearly qualifies under the new written statute to be to sit for the examination because the language is clear. It's not ambiguous. It's not up for outside interpretation because it's pretty clear and obvious that she meets these requirements. And so having successfully completed all the other sections of that section B of the statute, we're requesting that Miss Diana Hart is able to sit for her exam because under the clear language of this statute, she meets every qualification in there. And if there has been interpreted in the past that a person needs 3 years, then the statute has not been interpreted accurately as is written, because it could have simply said be actively engaged for 3 years and 1,500 hours. So there's no and in there. It's 1,500 hours. And the time frame that you have to have done it in is within or during the last 3 years. Again, we can't presuppose why, but it's assumedly because they don't want someone who said, I did 1,500 hours 15 years ago. Let me be a broker today. So, I mean, I'm guessing that that's probably why, but it doesn't even need to be subject to interpretation at this point because it is just clear on its face. And so we're requesting that Diana's application be submitted and that she doesn't need any exemption, it doesn't appear, because of the plain language.
Do you have it in front of you? Is it possible for you to read that so that we can hear the language?
Absolutely. So it says, each applicant applying for a real estate broker's license on or after January 1st, 2022 shall, before being admitted to such examination, prove to the satisfaction of the commission or the commissioner of consumer protection that the applicant, 1, has been actively engaged as a licensed real estate salesperson under the supervision of a licensed real estate broker in this state for at least 1,500 hours during the last 3 years immediately preceding the date on which the applicant filed such applicant's application. So that is the clear language of it.
Is there, what I don't understand is why this got flagged or blocked or so forth. I mean,
I'm sorry to cut you off. I think because when Diana originally applied, she made a waiver request when she didn't need to. And I think that that's what flagged it, and it sort of got lost in the shuffle along the way. And now it kept saying, well, we need a waiver. And we're saying, no, we don't need a waiver. Now that I got involved, it was, no, we actually don't need a waiver. It was, unfortunately, Diana's, messaging in the beginning, asking for a waiver when she never needed one.
Make a
How long
motion
has
on
she
this?
been actually licensed?
Point of information. How does one prove 1,500 hours?
It is through a signature of their licensed real estate broker. So they have to attest that the person has, in fact, done 1,500 hours. And that's how it gets done. So Diana has submitted that appropriately with her broker's signature stating that she has committed over 1,500 hours. But also it's kind of evident as well in the 16 transactions she's closed in the last 19 months. Whereas the other part of the statute only requires 4 within the last 3 years. She's done 16 in the last, 2+ years.
I was not challenging her ability. I just wanted a point of information as to how process was.
Of course.
Thank you.
No, thank you. I appreciate your question.
And how long has she been licensed? How many years?
I've been licensed. It's Diana. Hi, thank you all
Hi.
for taking the time to review this. I've been licensed in Connecticut since May of 2021. However, I have been licensed in California, where I was living and working right before I moved to Connecticut during COVID. I have been licensed in California since 2012. So I have been active in real estate as a professional for over 11 years now. And it's my sole job.
Broker?
Okay, so for clarity, you've been licensed in Connecticut for a little over 2 years.
That's
And
correct.
within that period of time, you have gotten the 1,500 hours and the 4 real estate transactions from May of 21 to May of 23.
That's correct.
Yes, I've actually closed 16 transactions in the last 19 months.
Okay. Thank you.
Thank you.
How many sales were there involved in those transactions? Were they any sales? Are they leasing? What are they? What are they?
They're both a combination of sales and leases. And for my particular brokerage, which is CAR, we're a national commercial brokerage, we only represent buyers and tenants. So we work exclusively for our clients. And there's no conflict in taking listings. So that's the culture of my brokerage, is that's all tenants and buyers. And I would say 1/3 of those 16 transactions are purchases averaging around $1 million each.
So what percentage would you say they're purchasing and what percentage was leasing of your
I would say 25 to 30% is purchases that I represent the buyer. And then the rest are leases, which we specialize in healthcare real estate. So my clients are doctors from the spectrum of dentist, dermatologist, therapy, med spa. And those leases tend to be 10 years to start, and then with 2 5-year options. So they're very long term.
Your license in California, was that a broker's license?
It was not a broker's license. We did not, no, I worked for Keller Williams and Douglas Elliman. And we do not need to have a broker's license in California to get paid for real estate services to be incorporated. So I was incorporated in California as a real estate professional, but I did not need the broker's license. Does that make sense?
Yes.
Okay.
You're looking for a broker's license to start an LLC to be able to get your commissions in. Mm-hmm.
That is correct, sir. That is correct because of the structure of doing this.
Ryan, I got a question for you regarding the law that they're interpreting. What is your feeling about that?
So I want to be careful here, and I did want to speak as we are familiar with the situation. Attorney Matt is correct that this really isn't a hardship question, it's an interpretation question. And the department isn't taking a position on whether or not the 1,500 hours needs to be completed over the course of 3 years or within the 3-year period as the applicant has put forward. We're also not the commission's attorney, and this really is a question that would be properly posed to the attorney. If you're asking, is this outside the bounds of a reasonable interpretation? The applicant's interpretation is not outside the bounds of a reasonable interpretation, at least from the department's view. But ultimately, this is a decision for the commission.
But again, it's interpretation.
Right, so I have a follow-up question on that then. All right, so we're saying that somebody has to have at least 15 hours within a 3-year period and 4 transactions. So if I work 40 hours a week for 50 weeks a year, I'm at 2,000 hours. So I really only have to be a real estate agent for 1 year to get my broker's license?
Under the language of this statute, yes. In the
All right,
clear,
so that, I don't know that that was ever our intention.
and so the intention of the statute doesn't come into play unless it's ambiguous. And because, as Ryan had indicated, it is not an unworkable or out of bounds. It's the plain language of the statute as written that courts take into account. So it's if there is an intention that was behind it that was not effectuated in the plain language, that's not something for the statute to be misinterpreted as that's concerned. And the key factor in that is that the last language of the last statute was very different. It said, has been actively engaged for at least 2 years. I mean, it's clear as day that that requirement then was 2 years. And so when it got changed to January 1st, 2022, whether or not the intention was to say you need 3 years, it would have to have the word and. It would have to say 1,500 hours and 3 years in order for the 3 years to be a qualifying factor. So the only qualifying factor is 1,500 hours. So for whatever reason the statute was behind it, it looks like they just wanted someone who was experienced in doing these rather than the number of years where you might have 0 experience in those years or 4 transaction, because the old statute also didn't have any closing requirements. So it was 2 years and that was it. So apparently under the old statute, if you hit 2 years, you don't even have to have completed a single transaction. You could say, oh, 2 years is up. I'm going to go be a broker tomorrow. And it looks like the statute was amended to say, well, look, let's say you need 1,500 hours of active work and close 4 transactions, not 15, 20 years ago, again, because we don't want that person to have no experience right now. Do it within the last 3 years to make
That's
it
fine.
qualifying.
All right, so yes, I understand that. And so my comment then is to the commission. So if you have somebody that's working 40 hours a week that does 4 transactions, rents 4 apartments, they can now be a broker if they pass the test.
Correct. Under the way those statutes
I'm not commenting to you, sir. I'm commenting to the commission because I don't think that that was our intention. And
That's
I
how it's written,
understand,
though.
so this is probably
If we want
something
to
that
rewrite it, it needs to be rewritten. That's how it's written.
Right, exactly, because do we want somebody who's been working for 9.5 months, 9 months, having a broker's license that's rented 4 apartments?
I think that's a different question for a different
No,
time.
I understand
Yeah.
it's a different question. And so, one, we have to look at this complaint or situation now. But then 2, I don't think our intention when we revised that statute was this outcome. So I don't know how we get that on DCP's radar that this now needs to be revised. And is
Agreed.
that's not something we can do through a reg, right? That's just that's a statute.
Ryan, how did we
That
clear
is-
this stuff up?
So this would require a statutory change to 20-314 if you felt like this is the interpretation proposed by the applicant is the correct interpretation, and you don't believe that that is the policy outcome you would like. That would require a proposed statutory change as we just went through. We could.
Believe the statutory interpretation of what this attorney has just told us is correct? As an attorney, do you believe that?
again, I'm not the commission's attorney, so I want to be kind of careful here. I
Who is that,
don't
Paulette?
believe. No, this commission
No.
would be the Attorney General's office. So what I can say is the interpretations that's being proposed is not facially unreasonable, which is why it's being why this was being
Challenged.
brought to the commission
Yeah.
at this time.
Okay, so then there's two things. So one, vote on this based on how the statute is written, and then two, potentially revise the statute next term because it's not what we wanted it to necessarily be. I mean, when we agreed to that previously, I didn't think somebody could become a broker in 9 months renting 4 apartments by passing another test. So it's just, you know, we might want to put an and in there.
I remember Amy's right. We were discussing this. That's exactly our fear war.
I'm inclined to wait for the AG's read on this.
Yeah.
I mean, so in this case, like, I don't know that we can deny Ms. Hart simply because what's been read back to us, it sounds like she's met those requirements. She's done well more than 4 transactions. She has a background in commercial real estate in a different state. I guess we have reciprocation with California? No, so you had to get your license here. Okay, so you had to pass your license test here to get a salesperson's license. So in this case, I personally don't know that I need the AG's interpretation of it. I think what we've heard is it sounds reasonable that she should be approved, but that was not our intention when we talked about this statute previously. So then it needs to be revised next year for next session.
Well, we're also, the only problem is establishing precedents. Once we do accept our application, I think we're opening up other things that were intent to happen. I feel more comfortable talking to the Attorney General's office myself.
Okay.
May I please add something?
Yes.
Again, thank you for taking the time with this. I'd also like to note that I do not want to open my own brokerage. I do not want to supervise people. I am happy with my current brokerage. I simply need to get my broker's license to be paid as a corporation or an LLC. That is strictly where this is coming from as far as purpose and intent. And as you can see,
the problem is that you could. The problem is that once we approve this, you can do all those things, and that's the larger issue. It's not what you're going to do; it's what you're enabled to do.
There's no separate stipulations on a broker's license. You can do whatever you want at that point. I realize this is what you're saying, but not necessarily on it's going to happen. That's my take on it, and my feeling is to discuss this with the Attorney General's office and get their opinion on it.
Ben, I'm a little concerned. I think that, we're saying basically it's bad law. So we don't like the result. So we're not going to approve it. We're going to wait. I think it's, if we all agree it's clear, even though it's the wrong result, we're kind of stuck. And I think it's sort of prejudicing this lady for, to have to wait.
Yeah, and I understand setting a precedent, but we set a precedent for a year until it can be revised next year.
Right.
I mean, it is what it is. It got screwed up.
Yeah, it's too bad, but.
Yeah, I was going to comment that what Ben had mentioned, it would be prejudicial to my client if it were not to be, voted on today.
How would it be prejudicial if we weren't comfortable in voting on it?
Because it has been opined, the clear language of the statute favors this outcome. And the only
reason, you can still vote on it and oppose if you prefer. Like, you don't have to vote in favor.
Our intent was, we changed it because our intent was 3 years, correct? We didn't think that 2 was sufficient. So, and we're hearing one opinion, one legal opinion, but we're not getting another.
Well, I think that we had the other legal counsel's opinion that what we said, although he's not permitted to endorse it, it is not unreasonable, he said, and is not unworkable. And therefore, if it does not have a clear clear opposition to it, then this is a workable, reasonable, plain and clear reading of the statute. Again, you'd have to put your feelings aside as if your intent wasn't written the way you intended it. Again, as I think Amy had mentioned, that's for the next legislative session. The way it's written right now is how we have to interpret it. And that's how statutes work. We can't say, well, we didn't mean this, so we're going to no, it has to be the plain language of the statute as interpreted and read. And then if it is not the outcome that you desire, it could be reworked and rewritten later to achieve the intent that you so desire. But that wouldn't be the normal course of procedure to simply oppose it now because it wasn't the intent. I understand that's frustrating on your end if that was your intent. I don't disagree with the idea that Amy had put forward that go and change it later. But as written, this person qualifies under the written rule of the state of Connecticut, and therefore we should not unduly delay her admission.
Attorney Zammit, I think you're doing a great job for your client.
Thank you.
We need somebody to do a great job for us to make our decision from a legal perspective. And that's why I still think we should do AG. For the AG's opinion. I agree with Sharon on what she just said.
And what, Mr. Chairman, if that is the direction that the commission wanted to go, is seek legal advice from your attorney, you could avoid any unduly prejudicial time delay if you chose to schedule a special meeting within a reasonable period of time to vote on this particular application without having to wait the 3 months till the regular meeting.
Everybody agreeable? All waiting?
I am.
Well, I guess.
Really, but how many of you are ready to vote now?
Ben, I'm
Wait, so
sorry.
what's the motion? Shouldn't there be a motion?
I would like to put in a motion to approve this when the chairman is ready. If the chairman is ready.
Second,
Sorry? All right,
second the motion.
a second.
What's the motion?
When was your-
Approve the application.
To approve the person's ability to move forward to take their broker's test.
Correct.
Without waiting for additional legal interpretation from the Attorney General's office.
Yeah, my part of my fear is if we can get approval in 10 days, I understand that. I don't know if we have the ability to get the Attorney General to look at this in a short amount of time. But also, I think the regulation is clear. Regardless of, in my mind, it's clear, regardless of our intention.
Ryan, how quickly can we get an opinion?
Unfortunately, I don't control the speed of which a constitutional officer's office moves. Sometimes they're very quick, sometimes they're very, very busy. So I can't make any guarantees.
I don't know about this time of year. It's probably a week or 10 days.
I don't know what the rush is. I just don't know what the rush is. Personally, I don't see that. It's not been indicated by Ms. Hart that she needs this ASAP.
May I speak? Linda, thank you for that. The reason this has come to the forefront of my particular situation through the work that I do is because I have been very fortunate and grateful to have done very well the past year or so in my real estate, which means the monies can be more efficiently invested and protected if I incorporate to help with my pension and security, my personal pension that I would have to fund as a corporation. Because as you know, IRAs or other investments, you can only invest so much. So the corporation's structure from the financial side for my future, because I'm a single older woman, I have to do this as efficiently and quickly as possible while I'm in this, for lack of a better phrase, prime earning years to help build up my future.
Diana,
COVID
when were
was
you,
very rough.
Diana, when were you originally going to take your examination?
I actually got scheduled for May 8th of this year, 2023. And I studied and studied for 3 days straight. I went up to Springfield and I had my piece of paper saying I was ready to go, and was denied at the site. So I've been working.
Well, then my point would be this, that it appears from what you told us when you applied for, when you started your 2 years as a licensed agent in Connecticut, that the May 8th was premature to your 2 years.
There is no 2 statute.
When did you first get your license? May 21. What was the date?
May 8th, 2021. And at that time, to your point, Linda, when I had my real estate training here in CT, it was 2 years before you could do your brokers. So within that time, I didn't realize the statute had changed. I was thinking, okay, May of 2023, it's been 2 years. I need to take the broker prerequisite courses. And that's when I I took them in March this year. And that's when I found out at one of the, through eCar at the trainings for broker, it's now 3 years. So I completed the training anyways, but then that's where this has come out.
I do just want to jump back real quick to the issue of what's the urgency. So, I mean, it's 3 months past the date that she would have taken her exam, and now scheduled to the next exam, take the exam, pass the exam, and this is all time that she, per statute, should have been allotted to have been a broker, earning her commissions in a different way. And so there is an urgency because we've already lost significant amounts of time, a quarter of a year, and how many transactions, that she had lost out on that under the reading of this plain statute she should have been entitled to. So that's why we are asking that it be ruled on, voted on today in her favor, because every day that goes by, whether it's 10 days or not, she's already lost a significant amount of time that she can't get back.
Okay, I just need to get clarification on something for myself, okay? I had asked Ms. Hart when she originally got her real estate license in the state of Connecticut, and your answer was?
May 8th, 2021. I passed the exam. The license, which again, I was new to Connecticut, the license was submitted once I started working at my brokerage car, and that was in July of 2021. I thought passing the exam, to be honest, I thought passing the exam meant that I was licensed. That's
okay,
how it.
So my further question is this. So July 12th, 2021, you were actually licensed in the state of Connecticut. So then you on this May 8th of 2023, you went for your exam, correct? And they denied you because you hadn't been licensed long enough, which appears to be the case. So for me, it sounds like you haven't lost any time at all.
No, so I'm sorry to interrupt. Anyone who's applying for a real estate broker's license after January 1st, 2022 is subject to this new statute. So the 2 years didn't apply to Diana because she went for her application after January 1st, 2022. And therefore, the 1,500 hours kicked in. Diana inadvertently, because she didn't understand the statute, put that she needed a waiver in her application. That's why it got flagged, and it never should have been flagged in the first place because she met all of the requirements under the plain language of the statute.
In other words, she doesn't need 2 years anymore.
No.
That's the problem.
Not 1,500 hours and 4 transactions.
Right.
Yep.
That's clear.
Thank you.
That's the way the new wording is, which we would like to look into and potentially change. But as of the current time, she does qualify under the existing law.
Correct. Thank you.
Mr. Sherman, would you like to take us to a vote?
Now that we have the discussion, yes. All in favor? Raise your hand.
Aye.
Aye.
All right, hold on a second. Linda,
Opposed.
Ed,
In favor?
Morag,
Yes.
Amy,
Yes.
Peter,
In favor.
Karen. Karen, I assume that's opposed.
I'm sorry, Ben. I thought my mic was on.
Sure.
It's a no.
Okay. Motion passes.
Thank you.
Congratulations.
Thank you very much.
Thank you very much. Have a
Good
great day.
luck with.
I greatly, thank you.
Anything else needed from us?
No.
Thank you very much. Have a good day, everyone. I
Nice to
appreciate
meet you.
Right.
Thank you very much.
Okay, next. Waiver to
Ben?
release- Sorry.
Ben?
Yes,
One of the, I think, you know, I think I don't want to let this go. I think we need to make sure that we explain our concern about this statute and get the process to get started to change it.
I will definitely, get on that and keep you posted what's gonna happen.
Okay, great. Thank you.
I think I know what our intent was, because we discussed this when this law passed. And then we get on it, all right, and I'll let you know.
Yep, thanks.
Okay, waiver requests from, Mr. Mike, is it Michael?
David McCool.
David McCool, I'm sorry, David. Okay, what is, let's see.
Would you like me to describe the situation, Ben, or?
Yeah, I got it here, but go ahead, why don't you do that?
Okay, sure. So, hello, Commissioners. I'm David McCool. Slightly unusual situation. So I have held a real estate salesperson's license in good standing for the past 30 plus years. Most recently held by Cushman and Wakefield for the past 16 years. In 2019, I left Cushman and Wakefield and joined a real estate company based in Dallas, Texas called Fisher. They did not have a broker of record, so I did go ahead and get my broker's license on 2/3/2020. Unfortunately, due to COVID, I was terminated a month later from that company on March 31st, 2020. 21, excuse 20, 3/31/2020. And so it took me 16 months to get a new job. And I got a direct corporate real estate job with Gartner, when Gartner is headquartered here in Stamford, Connecticut. I did not receive a renewal notice for my license. And since I technically don't require a license, since I'm a direct employee of Gartner, I don't require a license to represent them. And to be honest with you, Commissioners, I honestly lost track of the expiration date. And so the reason I scheduled this meeting is to appeal to your sense of equity. Given I've held a license in good standing for 30 plus years, I'm requesting an extension to get my continuing ed, to bring my broker's license back up to current standing, and then obviously pay any past dues that have incurred, that I would have incurred.
Okay. Any questions? So it's expired actually on, it's over 2 years.
I know it's over 2 years.
Yeah.
And
Yes, yeah.
what caught me by surprise, sorry, Amy, what caught me by surprise was when I did get when I switched from salesperson to broker, it became effective at the end of 2020. Excuse me, in February of 2020. And I thought it would have been good for 2 years, but it was less than that. And then I did lose track of it for that year. Because I came back to Mr. Cohen a year ago, inquiring about the extension.
Because it would have been expired since the May 31st, 2021, right? Because that was the renewal date for brokers licenses in 2021. We're just recently changing it to November now, but
Correct. Correct. And then I believe when I contacted Mr. Cohen, that was in March of 2023. So it had been, look, guys, it had been expired, and I kind of got caught up in this COVID, took a corporate job, and I did lose track of it. So I'm just, again, I've had a license in good standing for 30 years, and I would love to be able to, pass the continuing ed, which I've done every 2 years, and just get myself back on track.
Okay,
And I don't believe there's ever been a complaint filed against, my license in the 30 years either, by the way.
Would he have to sit for the exam again?
yes. Yes, I believe he does.
And you understand that?
It's a new application. I'm sorry, go ahead.
Okay.
I don't see why someone with an expired license doesn't have to go back and do the PPP and do everything all over again, unfortunately. I don't know. I think our hands are tied with my read of the regulations. I don't know that we can do this.
I don't think we typically do. I think it's just, you have to start again.
Yeah.
Okay.
It's not, I don't see too much of a hardship in that you're so experienced. To me, it's time and some expense, but, of a
Understood. I thought I would raise it as a potential.
We appreciate your points and bringing things out, and I'm sure you will do well.
One quick question. Do you have a license in any other state? An active
I-
license?
I do not, no. No. It's only ever been in Connecticut.
Be nice
Would
if
he be
the-
qualified to take the broker's test?
No, I
He's not eligible to take the broker's test without taking the PPP.
No, once he takes the ongoing ed, would he be qualified to take the broker's test? He doesn't have to qualify as a salesman again.
He would be. He would be a salesman's license he would be getting. Is Jill here? Jill, can you hear me? Jill Conklin?
Hi, Ben. I'm here.
Did you hear the question?
The question was,
His license does lapse. Okay, so the question is that if he has to reapply and he would become a salesman, he has had a broker's license, but he would be a salesman. Am I correct?
I'm gonna look him up right now. David.
It's MICKOOL.
I just want to get the most current if I'm. David Cool. Broker. So his license expired in March 31st of 2021, because the brokers used to expire in March. Now it's
Right.
November.
We
So-
all agree, yeah.
It was first issued in 2022, but then you have to go back to the sales license to see if he had 30 hours or 60 hours. So he was licensed in 99. So I'm going to say, based on that date, that he probably only had the 30 hours P&P. So he would need the 60 hours P&P to sit for the salesperson's exam. And the thing about the broker's exam, it says you have to be active in real estate, right? You have to be actively engaged in real estate for 3 years. So I don't know.
I had one other question for Mr. McCool. Now, you first brought this to the commission, you said a year ago?
Yeah, so when I submitted to Mr. Jason Cohen the extension request, it's dated on 3/19/2023.
Because I
So
think
not
there's
a
a
year
hard
ago.
line, and I think the hard line is after 2 years post expiration. I think that's where the hard, am I correct in saying that, Jill?
Yes.
Yes.
So if you had taken it at that time, there would have been a fee and a penalty, but you would have been fine. I think the issue is that we've now passed that. And you know, what we're trying to figure out is, was there a hardship that delayed you for that additional year or something like that?
Well, that's, you know, so I'm sorry, but that's what, so I did reach out, you know, before the 2 years, because I reached out on 3/19/2023. The license expired 3/31/2021. And so there was no way I could do the continuing ed within that 11 days. So that, I think that's where I really, you know, hit the snag, if you will.
You
If
can,
I
it's
could,
available online. You can do it, you know, continuously in a matter of a few days. There are several of these online sellers of CE that are that I personally use successfully.
Oh, okay. I didn't, unbeknownst to me, because typically when I was at Cushman and Wakefield, we would coordinate it as a team and go and attend the classes. So that's obviously my mistake.
So were you advised of the fact that you could take the tests online when you initially applied back in March?
No, I didn't realize.
11-day.
If I had known that, I would have clearly jumped onto those online
and also-
courses and completed it.
David, also in Connecticut, in lieu of continuing ed, you can take an exam for that. Pass that exam, you know, that
Right.
could.
Right.
Wow. All right, then.
so if I may, Mr. Chairman, just to give some framework for the decision that the commission has to make.
Mhm.
So there's a couple of different issues that are being discussed here. One is hardship and one is the ability to receive the license or sit for the exam. There is no hardship exemption for licensing requirements in the statute. The only hardship that exists is for the extension of time to complete CE. So you can expand the amount of time an applicant can take to complete their CE if they applied for a hardship. But the underlying licensing requirements are not waivable. What the commission does have is the ability to look at somebody's education experience and deem it equivalent to the licensing requirement. So if the commission were to look at the experience of an applicant and say, you don't exactly line up with what the requirements say, but we, in the opinion of the commission, deem it to be equivalent, that is a power within the commission. Typically, those powers are used for individuals from out of state, but there's nothing in the statute that limits your authority to deem it to any individual. Again, that's a discretionary power within the commission, and leave it to the commission to make a decision from there. I just wanted to put those kind of framework and guardrails on the decision.
Ryan, I did have a question related to that. Under what kind of circumstances might we decide to give someone more time to complete their CE? Because that's what Mr. McCool is asking for. He's asking for an extension of time to complete the CE.
Complete CE.
Correct.
That is a discretionary power within the commission. So you can determine whether a hardship has been demonstrated to your satisfaction.
Go ahead, Sharon. You're muted, Sharon.
So did I understand that the license actually expired in March of 2021? So if it expired in 2021, what would the process be to reinstate the license, regardless of what the continuing ed
You got
is?
2 years. If you, within 2 years, take the CE, you then pay a penalty and something like that, and you're fine.
And
The
you can
problem is after
reinstate it.
2 years, you lose
And-
everything.
And
And you're back to
continuing,
square one.
right, you have to have your continuing ed also completed.
Okay, so we've
But-
already
but
passed the
that's
2
like-
years.
So, but if we allowed for the extension for Mr. McCool and he takes the CE now, he'd be fine. But I can't, I'm
Not
seeing the
exactly,
hardship.
Commissioner
No?
Gray. Not
Please.
exactly, no, because it's 2 years of licensing expiration, not 2 years of CE completion. So if he had his license expired for a year, the commission could extend the CE for a year, but the amount of time that he has to reinstate versus reapply, that's from how long his license has actually been expired, and extending the CE period isn't going to change that 2 year.
So really, I mean, in the end, there's two things. One is I'm having a hard time understanding the hardship. And the other thing is I don't think there's much we can do to help, unfortunately.
I think in the past, if you go back, I think in most cases when we did extend continuing ed, was always normally it was medical reasons. So, but anyhow, so any more discussion? Otherwise, I'm looking for a motion.
Then I'll move that we deny the application.
Okay, second,
Second.
all right, all in favor?
Right.
Aye. Regretfully.
Opposed? Okay, I'm sorry, David.
Hey, look, I appreciate your time and consideration,
tried.
commissioners. I appreciate it.
Okay,
Thank you.
Good
Thank
luck
you.
to you.
wish you the best.
Good luck. Good luck.
Okay. Out of state C consideration. Eisenberg. Anything to that? Ms. Eisenberg here? Okay, we have here copies of CE certified school of real estate, certified of completion out of state. School that he had taken the course was with Jeff Weiss, who also we have accepted his school licensing in Connecticut. What state, does anybody know what state Mr. Eisenberg's from? Excuse me, Jill, do you know where Mr. Eisenberg's from?
What we got was from New Jersey.
Is it from New Jersey?
Mm-hmm.
Okay,
Yes,
And
it's New Jersey.
I'm sorry, is there a reason why we skipped the waiver request for Howard? It was McCool and Howard both had waiver requests. And then comes the Eisenberg one.
I apologize, I got Howard. Well, we can do Howard's.
Sorry.
Is Mr. Howard here?
I do not see him on. I do see a Brenda M who's had her hand raised. I don't know if she has any part of either of these or what her hand is raised for.
She's a guest, isn't she?
Correct.
Brenda, what's the question?
Just two quick things. One, when, if the mandatory course is not yet approved, when will we be able to teach that course?
Well, once it's approved.
my God, this is a joke.
Oh, hello? Did you hear me? When it's approved.
Okay, I don't see her on the meeting anymore, so.
Okay, continuing education hardship waiver for Raymond Howard.
I don't understand why if he's affiliated with a brokerage, the brokerage can't answer his questions as to when he needs to have his continuing ed completed. And what he needs to do. Like, I would think his broker should be able to provide him with that information.
You know. Is there a reason here?
There wasn't, I mean, there was no reason given other than he's been in limbo with his broker.
I don't see any hardship at all.
I don't either, honestly. You just missed
He
a
said
date.
it's with a referral network right now, but
Mhm.
I would assume somebody's overseeing the referral network.
Yeah.
And I went to the CTR website this morning too. It's so easy to see, you know, for anyone to see what courses are required and what's available. So it's not hard.
Okay, ready to make a motion?
Motion to deny the request.
Second,
Second, Berquist.
discussion, further discussion? All in favor?
Aye.
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 Opposed? Denied. Okay. Eisenberg. Okay, so right now, back to, Mr. Eisenberg. The certificates that we have, are for, he wants credit for, is, fair housing, understanding the appraisal, and code of ethics. Discussion? I mean, there's nothing regarding here specifically for state as a mandatory course. These will be electives. You
Can-
feel it's
Are we
necessary?
reciprocal with New Jersey?
I don't know if we are in New Jersey. Jill? Are you reciprocal?
Hello?
with-
No, we
No?
are not reciprocal with New Jersey.
So would we, is there any reason why we wouldn't accept this course if we wanted to? They don't have to be reciprocal, do they?
Mr. Chairman, my name is Ben Paholke. I'm a staff attorney with the department. There is a requirement that if we're going to grant reciprocity to another, to a licensee from another state, that state does need to be reciprocal with us. It needs to be a two-way street.
Okay. Were they ever, by the way? Was New Jersey ever? New Jersey?
That I don't know.
I thought they, okay.
A different question. Can we approve the courses that he has taken in Connecticut?
He just said no.
Oh, we can't.
No,
approve the
you
courses.
can't.
I thought
that's up
that,
to the
okay.
board. Yeah, the approving courses is irrespective of reciprocity.
I'm sorry.
So
Thank you.
Can't hear you, Jason. Please, again?
Approving courses is up to the board irrespective of reciprocity.
I think I can clarify.
Yeah.
I think I can clarify. There are three different concepts that all kind of intermesh: reciprocity, equivalency, and course approval. Reciprocity is when there's an agreement between two states that licensees from one state can just get a license in another state without a test. So that wouldn't even come before the board unless there was a new agreement. That's something, for example, New York just no longer recognizes Connecticut, and so there's no longer that agreement between the two. Equivalency is for an individual applicant. So you could, even if we don't have reciprocity with New York, for example, the board could look at an applicant from New York that has a broker's license there and say, you have the equivalent training and experience to a broker in Connecticut, and grant that license. That's a discretionary power of the board separate from reciprocity. And then there's course approval, which is a course that was taught out of state, could be looked at individually by the board, and the board could determine whether or not that CE course should be approved for credit by Connecticut licensing.
Ryan, but getting back to that, would we have to review the whole course prior to accepting?
What information you deem relevant for your review is, you can decide what you need to review.
When we do get these types of requests, I do generally encourage the applicant to provide as much information as possible, you know, about curriculum, any handouts they received, so that you can actually see what they learned as opposed to just the certificate.
And actually, this is a school, you know, these classes are similar classes. I don't know that they're the same, are approved in the state of Connecticut through this school. So, I mean, it's like the CE shop or one of those also. So to me, this is not much of a leap.
No, it seems like probably it's a boilerplated class, let's face it. What fair housing is fair housing. Understanding the appraisals probably doesn't, I'm sure it does not change somewhat. Code of ethics, I don't know. I don't think there's much variance it could be.
Yeah, now they look like good classes to me. We all on the commission fortunately have sampled this school's classes as part of investigating something else.
Yeah, but we are familiar with Kidney Certified School.
Excuse me, just the fair housing, Connecticut does have different fair housing regulations than other states. So that would be the only one that I would question, is the differences. You know, we have protected classes that not every state has adopted. So that's just one point for the fair housing certificate.
But isn't fair housing an ever-changing subject matter? Isn't it something that we all need to learn about every single day?
Agreed, and they change and they're adopted. So yes.
More discussion? Anybody want to make a motion then?
I'm nervous about calling it equivalent. I'd like to call it equivalent, but my fear is if we call this equivalent, is that tantamount to giving reciprocity? However, I'm not nervous about us, for me, you know, making a motion to approve the courses as acceptable as continuing ed. That I'm comfortable with.
But we don't know anything about those courses because no information was provided. We know the provider of the courses, but not those classes because those aren't ones the state of Connecticut has approved. Correct? And the guy didn't provide any information other than his approval certificate for taking the 3-hour class. Right? Like we don't have a transcript of the class or an agenda or anything like that.
That's correct. Now, also,
or at least not class. Yeah.
Are you certain that it is a 3-hour class?
I think the certificate said it was a 3-hour class. That's where I got the 3 hours
The
from.
reason I ask is I know some in different states, they have different hour lengths. So even a fair housing class could be a different length for a different state.
Good question, Peter, but this is 3 hours long.
I'm sorry, what's that?
Question, but they do, all 3 of them have 3 hours.
I think in the past, when we looked at this, we've always gotten at least a course, more information about what's in the course and what was covered. So I feel a little bit nervous about just doing it based on a certificate. I mean, you all know that, you know, the provider. I don't know the provider.
Could we find out if it's parallel to what is offered in Connecticut, those classes that we've approved from him, whether or not they're similar or
Shouldn't
basically
the
the same?
burden be on the applicant to provide this to us when
Yeah.
they submit their request? Like, the going back and forth it's like, provide your complete package. Don't ask us to find additional information to try to help you.
This is a situation, if we have any questions, which we do, if he has not provided us with what we need, then we can make a decision.
And they're not on the call. Like, they could be on this call as well if they chose to be.
I think they have to exhibit some, to Amy's point, they have to exhibit some professionalism, and I don't think this just throwing this at us in an email with their 3 certificates attached is professional. And if they want something bad enough from us, they need to present themselves.
Is it possible to request that, you know, for more information and for them to come back in 3 months when we meet again? Or is it just approve or deny? If it's just approve or deny, I think we have our answer for many of us.
Correct. The answer.
I
So,
think you always have a choice of deferring or postponing till the next meeting, taking action on something that's on an agenda. Just my opinion.
I
would.
want to know who's going to once we get these courses, who's going to review these and make sure they're acceptable to, by the way, just, you know, time-wise.
I mean, if he just provided a course outline, that might make, it might make me more comfortable. I don't know about everyone else, if that would make everyone else more comfortable. If he were to appear on the call and answer questions, it would certainly help me to be more comfortable. I don't know if anyone else would be helped by this.
I agree.
I'd love to give him every opportunity if we can
All right,
defer.
let's postpone this till we get more information from Mr. Eisenberg. Okay? Everybody agree?
I agree.
Yes. I have a random question about education. The education courses are being taught. Sorry, I have allergies for my throat is an issue. I was speaking to a realtor about love letters, and she said she took a course from Dynamic Directions, Ivy Lentini, and Ivy Lentini, or I guess her first name is Rhonda, was stating definitively that love letters are no longer allowed. And I was not aware of that. Is that correct?
Isn't that more of a NAR situation? I don't think it's anything passed legally.
Right. I don't think it is passed legally.
But
I don't think
that was not the set that, no.
No, and I don't think that's so I was actually the one that came up with the content for the love letter slides in the mandatory education. And that's not, if she said that are not allowed, that's not, that's not a statutory thing or a federal law or anything like that. NAR has suggested that those are not used because of fair housing, but I'm not in her class, so I don't know how she's teaching it, but I think that the content of the course says that these are not suggested, but they're not illegal in any sense.
Okay, I don't want to disparage this instructor because I too did not see her say this. I just was told. So I just wanted my own edification to understand.
I have actually taken that required class with Rhonda earlier this year through GAR, and she didn't teach it that way. So it's just, it's strongly discouraged because of fair housing, but it's not, there's no federal or state statutes that disallow it.
Okay, thanks for the info.
Just one note on Mr. Eisenberg. I did contact him on July 21st and informed him for full consideration by the board, you would need to provide additional information about the courses, including curriculum and handouts. the certs would not be sufficient. I did not receive any response.
Can we vote on it then?
Is there any harm in giving it more time?
Now, we've already said postpone, let's give him till the next meeting. And then we'll make a decision then. If he doesn't give us anything at that point in time, it's gonna be easy. Correct? Can't say we didn't give him a chance. Thank you, Jason. The next one is Mr. Blackburn, which is giving us a whole course here, assistant animal and fair housing.
Yep.
Did everybody download it? Right, so he's looking for credit received. Well, this was 4 hours, so it's over the 3 hours from the CE shop. Well, I didn't exactly can read it.
And this is just,
An elective.
sorry, so it would just transfer as an elective for a Connecticut elective? Okay.
Yes. It will be an elective. And I would be specific, by the way, if we do approve this, I want to make sure in the minutes that it does say this is to be approved as an elective.
Yeah.
So be no.
So this does not count as fair housing. This simply counts as an elective, because as fair housing, I'm concerned about it. As an elective, it's a class I would like to take myself.
Okay. The question is that assistant animals and fair housing.
My concern is, I think you covered it though, Mr. Chairman. My concern is that this can't count as fair housing because this doesn't cover the topics in fair housing that I think need to be covered.
Well, here's the problem. There's only 4 hours.
Did we receive a document that said what he's like, what is this? This is a waiver for one continuing ed or a substitute for one continuing ed.
All I have here is what you have. And it says here that he's looking for consideration for approval for CE.
But not whether it's for the fair housing CE that's required or an elective CE.
Yeah, I'm comfortable with it as an elective. Yeah.
Well, here's the other thing though. The question is that how is it divided? Is it 2 hours for assistant animals and fair house? I mean, is it? I don't know.
I'm able to be careful. Jason, if I'm correct, this did not come through our application process for approving mandatory courses. This came through our application portal for just approving CEs as we would for any other CE. There was nothing special about this application, correct?
Correct. Yeah, it's not
Right.
not seeking a waiver or anything with the application. It's just addressing, in the statutes or regs, I don't remember which, it does say that the board will consider courses that are not directly approved by Connecticut.
So I don't believe the credit sought here is to satisfy the mandatory course components. So I don't think that is something that the commission has to wrestle with today unless it chooses to.
Yeah, I think we should approve this as a not as a mandatory, as a what's the word I'm looking for?
Elective.
Thank you. Yeah, and if you're ready for a motion, I'd love to make that motion.
1 second here. When I have Jason. Jason, I got a question for you. In the past, these courses were approved by the department, didn't even come to us. Is this now all going to be coming to us for approval? Something changed?
Yeah, so there was, I guess, maybe a misunderstanding or ambiguity where they had been just approving courses, I believe, from maybe reciprocal states, but in reviewing the legal language, we've determined that there is no automatic approval. If it's not approved by Connecticut, it does have to come to the board. Now, that said, I've already expressed interest to Leslie that we should, and the board might want to think about this, we should consider formalizing that so that you don't have 1,000 applicants sending you their courses from other states to be reviewed here in these meetings.
Yeah, I think it was, I think once we start this, this is gonna be taking time consuming, and I don't think it's really necessary. To be honest, it's, the wheel was moving very well before. Now I'm not sure it's gonna move as smoothly. So, thank you, Jason, appreciate it.
No problem.
Everybody ready to vote? Make a motion, need a motion, please?
Sorry, I was off camera for a second. Yeah, I move that we approve this course as an elective.
A second, please.
Burke was seconds.
Okay, all in favor?
Aye.
Aye.
Opposed?
Aye.
One opposed, okay. Okay, pass accepted. As an elective course,
Correct.
please make sure that's in the minutes. Okay, real estate guarantee fund. You know, over the years, we haven't really had a dip into that guarantee fund. But it's there to protect the public. And this is definitely one for it. Let's discuss it. Open for discussion.
Ben, I can't remember, do they have to prove that they've tried to levy on the judgment?
Well, that was one of my questions I have here. Regarding this individual's assets, has that been reviewed?
So Ira Newman is here to answer any questions you have about his application. And so, Mr. Newman, are you still with us?
I am. Thank you for the time, committee and commissioner.
Yes, Mr. Newman.
So just a little background here, and then I'll answer the question. So it has been a 3.5-year process. Process started out back in January 2020, where we basically tried to attempt to collect from the individual Greg Saris, who was a registered real estate broker in the state of Connecticut. We sought assistance from Department of Consumer Protection. I went directly to Robert Brancato. He referred us to Jill Conklin, who I believe is on the line here. Jill was great. She really helped try and advise me on exactly what the next steps were, and she tried to make contact with Greg. Unfortunately, he was no-show, didn't respond to any of her emails. And where we left it was really she was going to go back to seek guidance from her director on best way to proceed. As time went on in October, I decided to go through the small claims process because Jill provided me info on the Real Estate Guarantee Fund, which I think, as you said, Commissioner, it is a great service to folks that do business in the state. I looked at what was required there, and it said I needed a valid judgment to apply for payment. So I did proceed with the civil trial. That went on for a year. I did receive a favorable judgment. In parallel, just for the record, I worked very hard with my wife, with the Bristol Police, the Office of the State Attorney, quite a bit of a process here, ultimately for them to pull a case together, which they didn't really want to do at first. But finally, just as of this past June, there was a guilty plea misdemeanor, larceny 4th degree that was submitted. Now, unfortunately, the whole process, going back to the collections, given the way this all panned out, where Greg took money that was supposed to be for rent as part of being a property manager, including security deposits that were submitted by our tenants. He pocketed all that money, and he's not had any address or information on file. So I have been working with Marshal Brian Mezik's office. The marshal is the one that originally served the papers. And in speaking to him and his team, Kayla and Donna, a couple of times, they said that even with a judgment, you still need to have some idea on location, whereabouts, to find local banks that they could actually get the information from if he has any assets available. And I've recently checked and tried to get additional info on whereabouts from the criminal side of this, but the police can't provide that info. It's subject to privacy rules. But I don't believe he's in the state of Connecticut anymore. From what I know, he is in Florida. He did start a GMARC consulting back then. I found information on it. So I've tried to do due diligence as much as possible to collect with my wife. And right now, even checking this past week with the marshal's office again, we need some sort of an idea on an address because unfortunately there's no central database across the United States, which lets you just find people if you have these types of circumstances.
Did you obtain a judgment from the court?
Correct. I have a judgment from the civil side, which was in my favor for the 49.90 total. And I also, again, have the information I provided to Ben. Thank you, Ben, for the criminal side of this, which just took place last month.
But you haven't given the judgment to a sheriff to try to enforce, have you?
Again, that's Marshal Resnick's office. There's nothing that they can enforce because they don't have any information to enforce it. There's no address. There's no information on file. He's let all of his certifications. Everything lapsed in the state of Connecticut, as far as we could tell. So it's one of these situations where you can't find the person. You can't collect anything.
Mm-hmm. This has happened before. The one thing about it, if Mr. Ferris ever comes back and wants a license, you will have to reimburse the state of Connecticut.
Right.
To give his
I saw
license for all this, the cost of this. So you got a copy of the judgment.
I believe that was submitted with his application, yes.
I have it. Yeah, I have it.
Was.
Did everybody get it? Download it?
Yes.
Okay, that's great. Okay, any more discussion about this?
I just want to, if there's any confusion about his requirements to collect and get a writ of execution, Mr. Newman had indicated to me that he had discussions with the sheriff's department, and that the information he relayed about the national system and whatnot, that's basically what the sheriff had told him. And so it's my personal opinion that he's made good faith efforts to make sure that he can collect on the judgment before bringing it to the commission. That's all I have to add. If anyone has other questions about the law, I'm happy to answer it.
Mr. Newman, it's been a tough road for you, and appreciate all the information and the due diligence that you did. It seems like, and I apologize. Sorry you had to go through this.
No, thank you very much. And again, I know everybody's done their best on your side too, and everybody I've spoken to has tried to provide assistance. It just, in case of anyone else, it sounds like you're always trying to improve process. To make it a little bit easier, just to find the answers. I know there's FAQs, there's information out there, but I did have to go back and forth a few times with Ms. Conklin, and now most recently with Ben. So just saying the folks are great, but if their information was in a better place to make it easier, it would definitely be good for others.
And that's something that we're actively working on.
Thank you.
Great.
All right, so I need a motion, by the way.
Motion to approve the request for the guarantee fund.
That's correct.
Is that enough?
Second.
Yeah.
Or do you want the
No.
amount? Do you need
Yeah.
the amount?
Yeah.
I think it's $4,000.
$4,990.
Correct.
I'll second the motion.
Discussion? Further discussion? All in favor?
Aye.
Aye.
Oppose? Pass. Thank you, Mr. Newman.
Okay, thank you very much again. Take care.
All right, is there anything new? Anybody want to talk about anything while we're here? If not, then I'm going to adjourn the meeting. Thank you so much for participating. Sorry about the
See you
mix-up.
guys
this
soon.
morning. Thank you.
Happy summer,
Thanks.
everybody.
Have a good week, guys. Bye.